Unauthorized use of a motor vehicle, auto theft. What's the difference? Have you been charged with one of these offenses? Listen, if you are facing an unauthorized use of a motor vehicle in Texas, you need to know what the law is. And my name is Jeff Hampton with the Hampton Law Firm. And today I want to go over with you the ins and outs of the crime of unauthorized use of a motor vehicle. What does the state of Texas have to prove? What is it that they would have to show in order to convict you and end up having this permanently on your criminal record? By the way, if you wait around to the end of this video, I'll also give you a free ebook, What to Do If You've Been Charged with a Crime in Texas. All right, let's jump into this. First of all, what is unauthorized use of a motor vehicle according to Texas law? Well, according to the Texas Penal Code, section 31.07, the district attorney's office would be required to prove the following elements of unauthorized use of a motor vehicle beyond a reasonable doubt. A person commits the offense of unauthorized use of a motor vehicle if he intentionally or knowingly, those are two big ones, criminal intent, intentionally or knowingly operates another's boat, airplane, or motor-propelled vehicle without the effective consent of the owner. Now, what is the sentence? What is the possible sentence for an unauthorized use of a motor vehicle? Under Texas Penal Code section 31.07b, the crime of unauthorized use of a motor vehicle is classified as a state jail felony, punishable by a minimum of 180 days in jail up to a 2-year prison sentence in a state jail facility. Now, here's the big question everyone always asks me. What's the difference between unauthorized use of a motor vehicle and auto theft? Now, although the crime of unauthorized use of a motor vehicle is found under the theft section of the Texas Penal Code, there is no requirement at all under the crime of unauthorized use of a motor vehicle that the value of the vehicle be established. You could literally be driving a junker that's not even worth $500. The value of the vehicle is irrelevant for this charge. So you can see one of the things we find, though, because this is a felony offense and because of what we're looking at here, many people think theft has to be proven. The state of Texas, under this charge of unauthorized use of a motor vehicle, does not have to prove theft. In fact, that's why this crime is many times referred to as joyriding. Basically, someone using someone else's car, dumping it off on the side of the road, not stealing it, but they had an unauthorized use of that vehicle, okay? Now, to be charged with auto theft, it's a little bit different. The state of Texas must prove beyond a reasonable doubt that you intentionally or knowingly took the property, car or truck, whatever the motor vehicle is, of another without their effective consent with the intent to permanently deprive the owner of that vehicle. Totally different crime. Something completely different than unauthorized use of a motor vehicle. So the unauthorized use of a motor vehicle, here the focus is going to be on the intent to operate another person's vehicle without their consent, not so much on whether or not you intended to permanently deprive them of the vehicle. So let's talk about a few defenses. Here's where it comes up. You need to know in a situation like this, it's very important that you not only hire an experienced and aggressive criminal defense attorney to help protect your freedom and your future and your clean criminal record, but you need to also have an understanding of what you're facing. What are some of the legal defenses available to you under Texas law in order to help you fight this charge? So one of the things we find right out of the gate, one of the best defenses you have is that you don't have to prove anything. The state of Texas always has the burden of proof to prove the case beyond a reasonable doubt. So if there are any doubts related to their ability to prove each and every element of the crime, it should tilt in your favor. Now let's talk about how some of those doubts can be created. Number one is the defense of consent. The prosecutor is required to prove beyond a reasonable doubt that you did not have valid consent of the owner to operate the vehicle. Now, what if there is reasonable doubt to believe that you did have consent to operate the vehicle? What if there is reasonable doubt because you had previously operated the vehicle of the alleged victim here and you had reasonable belief that you could operate the vehicle? I'm going to give you an example. We represented a client where he was arrested and charged with unauthorized use of a motor vehicle because the client's mother, became so angry that her son had been out driving his parents' classic car. I mean, this was like a $75,000 car, really nice classic car. She became so enraged about her son's behavior that she immediately called the police and asked for him to be arrested because he did not have her permission to be driving that car. Now, here's the issue. Our client had previously been given permission to drive that vehicle, and that piece of evidence was very important for us to know. But most importantly, what the mother did not know, and what the police did not know at the time, is that the father had told the son that if he had taken care of what he was supposed to in terms of that day, his requirements of getting things done for the day, that his father was going to allow him to drive the vehicle for that evening. In this instance, we met with the father, had him provide a sworn affidavit, and we used this as our primary weapon in order to help get our client's unauthorized use of a motor vehicle case dismissed. Now, this same defense holds true for the crime of auto theft. The state of Texas would be required in that situation to prove beyond a reasonable doubt that the owner did not consent to you taking the vehicle at the time of the alleged crime. And if there is evidence through maybe text messages, emails, voice messages, or something along those lines showing that you had previously been given consent to drive that vehicle, you had a reasonable belief that you could operate that vehicle, that would help establish you had no criminal intent to permanently deprive the owner of that vehicle. Okay. Now, number one is consent. Number two is lack of criminal intent. Now, similar to the defense of consent, the state of Texas must also prove beyond a reasonable doubt that you intentionally or knowingly operated another person's vehicle without the valid consent of the other. Now, how does this criminal defense apply? What if you individually believed that you had received valid consent to drive someone else's car? I'm going to give you an example. It's kind of hard to illustrate this without an example. We had a client that had been arrested for unauthorized use of a motor vehicle. He was driving it because the vehicle that he was driving, he thought he was allowed to drive. It was his friend's vehicle. And let me give you kind of a backdrop of what happened. He had been spending time together with his friends and asked if he could run to the store to buy some food, some drinks, and different things like that. Well, one of his friends threw some keys to him and said, "Yeah, go get it. Go get what you need to get." And so he went. The problem was he was gone for a while. He was gone quite a bit longer than they expected. And then the owner of the car comes out of the restroom, sees that his car is gone, freaks out, calls the police and says, "I don't care what this other guy said. I didn't say that he could drive my car. He did not have my authorization to operate the vehicle." Now, did our client commit unauthorized use of a motor vehicle in this situation? No. Auto theft? No, absolutely not. In this situation, not only did the client not have the criminal intent to permanently deprive the owner of the vehicle under a theft statute, he acted under a reasonable belief. He reasonably believed that he did have consent to operate the vehicle when driving it to the store. He was of the belief he was driving the person's car who threw him the keys. And that would have been a reasonable belief. Now, the way we had to deal with this was to gather witness affidavits from the guy who threw him the keys, showing that, yes, I threw him the keys and he fully believed that it was my vehicle. And we were able to present that to a grand jury to help get his unauthorized use of a motor vehicle case thrown out. Now, listen, the consequences of a conviction for an unauthorized use of a motor vehicle are unacceptable if you're a first-time offender. It's a felony offense. So if you were to do a plea deal that resulted in a conviction, you would never be able to get this off of your record. You would be a convicted felon. You would lose your gun rights. You would lose your right to vote. There would be many limitations placed upon you. And so a conviction for a first-time offender is not an option, and you need to make sure you have an attorney that's going to fight to protect you from that result. So one of the main goals that everyone that calls the Hampton Law Firm has similar goals. And I'm just going to go over them very quickly. Number one, stay out of jail. Your attorney should do everything they can within their power to prevent you from ever having to go to jail. Number two, avoid a felony conviction. I've already covered with you the serious ramifications of becoming a convicted felon. It's not an option. Number three, you need to do what you can to make sure your criminal attorney not only can help you avoid a conviction, but also resolve your case in a manner that allows you to get it off your criminal record. You want to be able to clear your criminal record. And I've already kind of alluded to this a little bit, but one of the best ways to do that is to present favorable evidence on your behalf to the grand jury. The grand jury is a panel of citizens who can listen to evidence. And in both examples that I gave you just a few minutes ago, that information, those witness statements, could be presented to the grand jury, and the grand jury could either keep the charge as a felony, they could lower the charge down to a misdemeanor offense, or in this case, no bill the case. And a no bill is the equivalent of a flat out exoneration. Your case is dismissed. It allows you to be eligible to get the charge and the arrest expunged from your record. Now, even if it is not no bill, there may be other options. You may be able to have your attorney negotiate the case down to a lesser charge, or ultimately a conditional dismissal where maybe you complete certain terms and conditions in exchange for a dismissal. Or listen, if the prosecutor ends up being unreasonable in the way that they negotiate with you, you always have the right to a jury trial. And if that ever comes up, you want to make sure you have a team of defense attorneys that have the experience and the know-how in order to be ready to help you fight your case in front of a criminal jury. Now, listen, I hope this information I've shared with you here today is helpful for you. If you are facing an unauthorized use of a motor vehicle in the North Texas area, don't hesitate to contact the Hampton Law Firm at 817-877-5200. I'd be happy to give you a free case analysis and a free consultation. And by the way, I promised you wait around to the end of this video, I'll give you a free ebook, What to Do If You Have Been Charged with a Crime in Texas. Click the link down here below. I'll be happy to send it over to you. I want to thank you again for joining us here today. If you've enjoyed this video, like this video, subscribe to our YouTube channel, and I'll continue to send you great content under Texas criminal law. Have a great day.